Thank you. All right, today's Tuesday, November 7th, 2023. It's 9 a.m. We are here in council chambers for the hearing examiner hearings, which I'm now calling to order. Before we start the hearings, I'm going to provide a couple of comments about our process. The process that's followed here in Cape Coral is a little bit different than that followed in other jurisdictions. In our process, the clerk will read the introduction to the case, and then the clerk will swear in anyone who is testifying. City staff will testify regarding compliance with public notice. If public notice has been properly accomplished, we will go forward with the hearing. If not, we will take another route that will be discussed at that time. The applicant, assuming public notice has been found, the applicant will go first and present their entire case. City staff will go second and present their case. Public comment will then be opened. If you're here for public comment, please make your comments comprehensive, because once public comment is closed, it will not be reopened. Following the closure of public comment, the applicant will respond to questions and make any final comments. Staff will do the same, and then the hearing is concluded. Please come to the microphone if you have testimony today, because we will not accept any testimony from your seat. All testimony must be under oath. If you're here and for public comment, please go to the microphone on my left, your right. It has the same video and audio capability as the other one. The applicant and staff are welcome to use the one that is directly ahead of me, as you know. Anyone who provides testimony other than the applicant and staff is requested to fill out a public participation card so that we can properly spell your name. Also, if you wish a copy of the hearing examiner order or a recommendation, as the case may be, please provide your email address. However, please also be aware that once you do that, your email address becomes public record. If you have a cell phone with you today, please turn it off or silence it if possible, and take any cell phone conversations outside the room. Finally, if you wish to have private conversations, please move away from the lectern, because we do not want to accidentally record your comments. If your comments are recorded, they become public comment at that time. With those preliminary comments, I'll turn it over to the clerk for our first case. Thank you.
Case number DEV 23-000008. Address 5809 Chiquita Boulevard South. Applicant Keith Leander. The applicants are requesting a 7-foot deviation from section 5.4.3.3.b of the LDC to allow a marine improvement on a canal end located at 5809 Chiquita Boulevard South to project a maximum of 37 feet into Beethoven Canal. The LDC currently limits marine improvements on canal ends to project a maximum of 30 feet into a waterway. Any persons giving testimony today, if you are able, please stand and raise your right hand. Do you solemnly swear or affirm to tell the whole truth and nothing but the truth?
I do.
Thank you.
Thank you, Madam Clerk. Good morning, Mr. Heller.
Good morning, Madam Hearing Examiner. Justin Heller, Senior Planner with the Cape Coral Planning Division. Just want to say for the record that this case was noticed with a sign placed on the property, mailings sent out to all properties within 500 feet, and an ad run in the local newspaper 10 days prior.
Thank you. I will find a proper notice was given.
Thank you.
Thank you. May we have the applicant up? Thank you. Good morning, sir.
Good morning. I'm Keith Miller. I live at 809 Chiquita Boulevard South, and I am requesting a deviation to extend my dock out to 25% of the canal, or 37 feet. In doing so, I don't believe it would impede anybody's in anybody's way to navigate the canal. Obviously, down the way, people park their boats on the outside of their slip, and there's never been a problem. Plenty of room. In effort to give more room to the lady to the south, I had originally a 16-foot well. I've shortened it to 14 foot, and everything to the south of me was dockage. It was a big platform as far as you could go. That's all going to be gone, and you can see in the new drawing that it's going to be a lot more open for the lady to the south, and safer for me to be able to pull out and pull up and load the people and gear on the boat to go for a ride. So pretty much I think you got everything there. If you have any questions, I'd be glad to answer them. That's
Thank you. I do have a question. There are certain standards that are set out in the Land Development Code. Have you had an opportunity to review the staff report?
I have.
Do you wish to incorporate the staff report into your presentation today?
I do. Yeah, that would be great. Yes,
Okay, I have no other questions. Thank you, sir.
thank you.
All right.
Anybody else, or that's it?
No, don't go away.
Okay.
There's more to come.
Okay.
You can sit down if you want, but I will be asking you to come back up. Mr. Heller? Thank you, sir. I'm surprised you're not asking to be qualified as an expert, given how many of these you've done in the past, but we move on.
Hi, Justin Heller, Senior Planner with the Cape Coral Planning Division. At this time, I would like to be recognized as an expert in the field of planning regarding matters similar to this case, based off of my CV, the clerk's office, and previous testimony.
Thank you. I will find you as an expert regarding matters that are relevant to this dock deviation case based upon your prior testimony regarding matters and issues that are similar to those before us today, and also based upon your CV, which is of record with the clerk's office. Thank you.
So the applicant is requesting a 7-foot deviation from our Marine Improvement Standard Section 5.4.3.3B to allow them to have a marine improvement at a canal end that extends 37 feet into the waterway. The site has single-family future land use with single-family zoning. The site's at the end of a canal, and they have about 55 feet of water frontage on Beethoven Canal, which is about 150 feet wide in front of their property. Canal ends are limited to a maximum projection of 30 feet into the canal. And this property in particular has a joint marine improvement agreement with the property to the north of them at 5805 Chiquita Boulevard South. Here's an aerial of the site. That was the previous dock. I guess that was destroyed by the hurricane, according to the applicant. The shared dock would be the one to the north per that agreement, joint agreement with the neighbor. Now here's a sketch of their proposed new dock. This would allow the applicant to come straight in and back straight out of their property. So we analyze this under section 5.411A. First standard, the effect of the proposed deviation would have on the navigability of the waterway involved. We find the proposed marine improvement would be located near the center of the end of a 150-foot wide canal and should not impact the navigability of the waterway. So we found that the standard was met. Standard 2, whether the proposed deviation would infringe upon the use of the neighboring properties or any extant marine improvements upon the use of neighboring properties or any extant marine improvements in the subject waterway. We find the adjacent neighbor to the north, who the applicant shares a joint marine improvement with, has provided a letter of no objection. And we find the location and orientation of the marine improvement are such that the requested deviation should not interfere with any adjacent property owner continuing to use their respective marine improvements. So we did find that this standard was met as well. Standard 3, whether there is any special conditions related to the subject property or waterway which justify the proposed deviation. We found the site has 55 feet of water frontage, and this is less than your average Cape Coral 80-foot wide lot. The safest way to store a longer boat on this narrow site would be perpendicular to the seawall, allowing them to pull straight in and straight back. So we did find that this standard was met. Condition 4, whether conditions exist that are not a result of the applicant and which are such a literal enforcement of the regulations involved would result in unnecessary or undue hardship. Firstly, we find the site water frontage significantly less than a typical 80-foot wide lot and creates conditions that are not a result of the applicant. Hurricane Ian also damaged their existing dock, and they are now trying to redesign the dock in a better configuration before rebuilding. A literal enforcement of the regulations, however, would not result in an unnecessary or undue hardship, as the applicant could simply rebuild their dock to their prior permitted design. This deviation, however, would allow them to safely moor their boat perpendicular to the seawall. Having the dock extend perpendicular to seawall as opposed to at an angle or parallel allows for the best access to their site without interfering with any adjacent marine improvements, and as such, we find that this would be in the public interest. So we did find that the standard was partially met. As far as the comprehensive plan, we find it's consistent with policy 1.15 of the future land use element. The R1 district is consistent with the single-family future land use classification. We also find it's consistent with objective 1.3 and policy 1.3.5 of the conservation and coastal management element. The deviation does not propose introducing any new fueling or repair facilities in a residential area. The Cape Coral Planning Division is recommending approval of this request with the following conditions. Condition 1, the dock shall be constructed with a maximum 37-foot projection into Beethoven Canal, consistent with design of the marine improvement depicted in Figure 2. The joint marine improvement agreement between 5809 and 5805 Chiquita Boulevard South shall be revised to include the new configuration of the marine improvements, and a copy of this updated agreement shall be submitted to the City Planning Division for review and approval. The condition 3, the revised joint marine improvement agreement shall be recorded by the applicant with the Office of Lee County Clerk of Court prior to any marine improvements building permits being issued for the site. And condition 4, the city shall record this deviation with the Office of Lee County Clerk of Court following receipt of recording fees from the petitioner. That's all I have for you, and I'll stand by if you have any questions.
Do you wish to incorporate your staff report into your presentation?
Yes, thank you for reminding me. I do wish to incorporate my staff report into my presentation.
Okay, thank you. I have no other questions. This is a public hearing. Are there members of the public who wish to provide input or testimony? Seeing none, I'll bring it back to the applicant. Mr. Leander, could you come up, please, sir? Thank you. You've heard the testimony of staff regarding your application today. Do you wish to incorporate that testimony into your testimony as well?
Yes, I do.
Okay, thank you very much. All right, Mr. Heller, anything else? Other than giving me a copy of an exhibit that you have in your hand?
No, ma'am, that's all I have for you.
Okay, I have no other questions. I will find that standard 4 was met as entirety, not partially, based upon my review of the documents and based upon the testimony here today, so I will grant the deviation as requested. Mr. Leander, it sounds like your dock and you have gone through some horrific times with the hurricane, as many of us have, so my part of this is going to be pretty fast. I will attempt to get the deviation order out today. As I said, attempt, but I'll do my best, and then that'll get you on to the next piece of this, all right?
Well, thank you.
And thank you for sticking with Cape Coral. I know a lot of people left after the hurricane, so thank you for that. All right, closing that hearing, moving on to case number 2. Madam Clerk, thank you.
Case number VAC 23-000010, address 1729 Southeast 39th Street, applicant Brian Haig. The applicants are requesting to vacate 2,000 square feet of street right-of-way, row, and underlying easements to vacate 504 square feet of platted easements in lots 34 to 35, block 544, unit 11, Cape Coral subdivision. The vacations are proposed on or near properties addressed as 1733 and 1729 Southeast 39th Street. If approved, this will enlarge the property 1733 Southeast 39th Street and increase taxable property. Any persons giving testimony today, if you are able, please stand and raise your right hand. Do you solemnly swear or affirm to tell the whole truth and nothing but the truth?
I do.
Thank you.
Thank you, Madam Clerk. Good morning, Mr. White.
Good morning, Madam Hearing Examiner. For the record, Patrick White, Senior Planner downstairs in DSD City Planning Division. At this point, I'd like to acknowledge this case was duly advertised, including we posted signage on the property. We put a mailing in to properties within 500 feet of the subject properties. And we also placed a legal ad in the news press.
Thank you. I will find that proper notice was given.
Thank you. I will also at this point go ahead and request for recognition as an expert witness on this case based on prior testimony and my CVs available downstairs in the city clerk's office.
I will find you as an expert based upon your prior testimony regarding issues that are similar to the issues before us in this hearing today, and also based upon your CV of record with the hearing examiner, record with the clerk.
Thank you.
Thank you. All right. Good morning, sir.
Good morning, ma'am. Brian Hogg, Windward Construction. As we have so often times before, we're coming before you this morning to request a vacation of plat on a hammerhead on one of the lots at the end of a cul-de-sac to make this lot more buildable and kind of what would be contemporaneous with what's happening in the market today. So this is going to allow these people to have an oversized garage and the living square footage that would be appropriate for a lot of this value. We did reach out to the neighbor to the west, and he has signed the application and has no objection to giving the entire hammerhead to the 1733, to our owner, Mr. Johannek. So I do believe we have met all the criteria for the vacation with the city, and that's what I have this morning.
Do you wish to incorporate the staff report into your presentation?
Yes, ma'am.
Okay, thank you. I have no other questions. Thank you. Mr. White, thank you.
Thank you, Madam Hearing Examiner. I have a brief PowerPoint presentation for this case, VAC 2310. The applicants, Rick Johannek at 1733 Southeast 39th Street, and David Carlisle and Robert Carlisle at 1729 Southeast 39th Street. We'll zoom in on these lots momentarily. Together, they're requesting to vacate 2,000 square feet of street right-of-way and underlying easements, and 504 square feet of platted easements along lots 34 and 35, all within block 544. The aerial map on the left depicts where these two lots are located, kind of, at a city extent. They're in southeast Cape Coral. The future land use of the property is single family, as are all surrounding properties. Similar situation with the zoning map. Zooming in, we can see the two properties here depicted in blue, depicted with a red outline. That blue area is a sketched-in area of the the street right-of-way or hammerhead vacation that is proposed. It is also represented in Exhibit 1 within your packet. Exhibit A. Exhibit B depicts the public utility easement that would be vacated on the rightmost property. It is also identified as Exhibit B within your packet. And Exhibit C is a reserved public utility easement that the city will keep in order to retain our perimeter 6-foot public utility easement. The application was submitted by Mr. Brian Hagg of Windward Construction, who's the authorized representative of the owners. The eastern property was cleared in January 2019. The owner does plan to build a new home. The vacation will enlarge the area of the eastern property only. In reviewing these, staff examines whether they meet the criteria from LDC section 3.4.5.b 1 through 5, and I'll briefly review those. Item 1 questions whether the plat, easements, or right-of-way are required by the city for future transportation, access, water management, or public utility purposes. Staff found that the right-of-way is at the end of this Southwest 39th Street. It constitutes a dead-end street. It's located between two willing applicants. The city does have a stormwater inlet and a drainage pipe which will be relocated in order to accommodate the proposed vacation. The applicant will relocate the inlet and the pipe in the city right-of-way in coordination with Public Works Department as written and in the proposed conditions. There are a number of platted easements in lots 34 and 35 that are proposed to be vacated. These are no longer needed. They'll be located interior to the property. Instead, we're reserving public utility easements along the periphery of the expanded site in order to maintain the city's required 6-foot perimeter PUE. Item 2 questions whether there are any required easements necessary to accommodate the vacation. Like I said, the platted easements that are vacated are not needed. The city will retain a proper perimeter easement. sufficient for maintaining our 6-foot PUE. Item 3 questions whether or if alternate routes are required or available that don't cause adverse impacts to the surrounding areas. Staff found the existing cul-de-sac is not going to be impacted by this vacation request. No alternate routes will be required, and the vacation should not have any adverse impacts to the surrounding area. Item 4 questions if the closure of a right-of-way negatively affects areas utilized for vehicles to turn around and exit. Again, staff found that the vacation will not impede the ability of vehicles to turn around and exit the area by using the existing cul-de-sac. Item 5 questions whether local utility providers have given consent to the vacation. Staff found that all 3 utility providers have provided letters of no objection. LCEC asserted that they require a continuous 6-foot PUE, which is in place. Comcast stipulated if facilities are found or damaged, that the applicants will bear the cost of relocation and repair. The next thing staff looks at is the comprehensive plan. There's staff found that in policy 1.15 or 1.15 that the property's R1 zoning designation is consistent with the single-family future land use, and that the request is consistent with policy 1.15A. Both sites will be developed with a density less than the maximum of 4.4 dwelling units per acre. Staff's recommending approval with a number of conditions. Condition 1 being that the vacation of the 2,000 square feet of right-of-way and underlying easements shall be consistent with the sketch and an accompanying legal description prepared by Harris Jorgensen LLC, labeled Exhibit A. Condition 2, the vacation of the 504 square feet of platted easements in lots 34-35, block 544, shall be consistent with the sketch and accompanying legal description prepared by Harris Jorgensen LLC, entitled Exhibit B. 3, that the city shall retain easement sufficient for maintaining the minimum 6-foot wide public utility and drainage easement around the perimeter of the site located at 1733 Southeast 39th Street, consistent with the sketch and accompanying legal description prepared by Harris Jorgensen LLC, entitled Exhibit C. 4, in the event utilities are found within the vacated area, the owners shall be responsible for bearing the cost of relocating the facilities to a new easement. In the event utilities are damaged during construction, the owners shall bear the cost of relocating the utilities to a new easement and repairing said utilities. Condition 5, the vacated right-of-way will be private property and shall no longer be maintained by the City of Cape Coral. All publicly maintained infrastructure must be removed and relocated to a new location of the right-of-way or public utility easements. Therefore, within 180 days of approval of this vacation request, sub-item A, the owner shall remove the pavement associated with the vacated street that occupies their site. The area shall be sodded following the removal of this pavement or may be improved as permitted by the Land Development Code. And B, that the owner shall obtain the necessary permits to remove the existing stormwater inlet located within the vacation area, relocate the inlet into city right-of-way, and install the necessary pipe to connect the existing pipe to the new inlet. At the sole discretion of the city, the owner shall grant all necessary easements for any new or modified stormwater system if required. All improvements shall be permitted through and inspected by the city. The cost of the improvement identified in these conditions shall be borne by the owners. Condition 6, the owner shall pay to the City of Cape Coral the cost of recording this resolution with the office of the Lee County Clerk of Court. And lastly, Condition 7, that the city shall record this resolution with the office of the Lee County Clerk of Court following the receipt of recording fees from the owners. With that, I end my presentation and stand by for any questions.
I have no questions, thank you.
Thank you.
This is a public hearing. Are there members of the public who wish to provide input or testimony? Seeing none, I'll bring it back to the applicant. Yes, sir.
One thing to add,
Yes, sir.
I did receive 2 phone calls related to this case, both with just inquiries. Neither supported or opposed the application.
Thank you for that addition. All right. I think I closed public comment, so back to the applicant's representative. Yes, sir. Anything further?
No, ma'am.
Do you wish to incorporate staff's testimony today?
Yes, we do.
Okay, thank you very much. Mr. White, anything further? I will assume not, but,
I guess I would also like to incorporate my staff report into my presentation.
okay.
Thank
you. Done. All right. Having nothing further coming in front of me regarding this hearing matter, I will close the hearing. I will recommend that this be granted as requested. Mr. Haig, you've heard me say this many, many times. Time is money. I will attempt to get this out as quickly as possible so you can proceed with your building. All right, thank you very much. Having closed that case, let's move on to the next one. Madam Clerk, thank you.
Case number VAC 23-000011, address 1110 Lorraine Court, applicant Arnold Egan. The applicant requests to vacate 354 square feet of canal right-of-way, row, and 408 square feet of platted easements adjacent or occupying lots 5 and 6, block 0010, unit 1, part 2, Cape Coral subdivision. The property is located at 1110 Lorraine Court. If approved, this will enlarge the subject property and increase taxable property. Any persons giving testimony today, if you are able, please stand and raise your right hand. Do you solemnly swear or affirm to tell the whole truth and nothing but the truth?
I do.
Thank you.
Thank you, Madam Clerk. Good morning again, Mr. White.
Good morning again, Madam Hearing Examiner. Again, for the record, Patrick White, Senior Planner downstairs in the City Planning Division. At this point, I would like to acknowledge that this case was duly advertised, including mailing properties within 500 feet of the subject property, legal notice placed in the news press, and a physical sign posted on the property in accordance with city rules.
I will find the proper notice was given. Thank you.
At this point, I would like to request expert witness status based on my CV and prior testimony on matters such as this.
I will find you as an expert based upon your prior testimony regarding matters that are similar to the issues before us today in this particular case, and also based upon your CV, which is of record with the clerk's office. Thank you. Good morning, Mr. Egan.
Good morning, Madam Hearing Examiner. I am Arnold Egan. I am also one of the members of Team Patriot that actually owns that property, and I'm also founder and one of the owners of Arnold Roberts Signature Homes that is building a home on that property currently. First thing I want to do is compliment your staff on their comprehensive and well-organized efforts and the presentation that I was able to read. I would like to reiterate our reasoning for this vacate request as included in our vacate request from the letter that we sent over on March 13th, 2023. The existing seawall at the rear of the property is in line with the seawalls of the two adjacent properties. The location of the current public utility easement at the rear is unusual. The vacation will only affect the rear of the property lot line. We will provide a new 6-foot public utility easement extending along the length of the new property line. The resulting condition will match what has been done on similar lots in this area of the city, where the rear lot was not extended as a result of the land accredited during the seawall construction. Vacating the requested land will return this land back to the tax rolls and allow us to improve that site fully. Down that area by the Cape Coral Yacht Club, there's some very, very nice homes going up on there. We want to build something that is comparable for that area. And then also, it's going to increase the value of the land, of course. We do agree with the staff assessments that I was able to read, and will abide by all the staff specified conditions included in their recommended approval. With that, I thank you for your time and addressing this issue that is extremely important to both Team Patriot and Arnold Roberts Signature Homes.
Thank you, Mr. Egan. Do you wish to incorporate the staff report into your presentation today?
Yes, I do.
The reason I ask you that is that there are certain standards in the Land Development Code that are, it's a pretty rigid situation where each factual finding needs to go with each standard, and the staff report does address it in that fashion, so.
It addresses it quite well.
Oh, well, you got 2 compliments, Mr. White. Congratulations. Thank you, sir.
Thank you.
It's always nice to hear compliments for staff. It's unfortunately not as common as we would like.
We'll take them when we can get them, Madam Hearing Examiner.
We got 2 for 1 today, Mr. White, my goodness.
Again, for the record, Patrick White, Senior Planner downstairs in the City Planning Division. I have a brief PowerPoint presentation for this case, VAC 2311. The applicant is Team Patriot Southwest Florida LLC, and the property is located at 1110 Lorraine Court. That's within Unit 1, Part 2, within Block 10. The applicant is requesting to vacate 1,354 feet of, well, I might have a typo there. Let me double check that number. The applicant is requesting to vacate canal right-of-way and platted easements, and we'll firm those numbers up momentarily.
That's okay, take your time.
Thank you. The image on the left depicts the property in southeast Cape Coral. The future land use map depicts the property as single-family residential, and the zoning map similarly depicts the property as single-family residential, as are all other surrounding properties. The vacation area depicted in blue on the aerial on the right is also the same as Exhibit A. It is the canal right-of-way vacation area. Exhibit B is a public utility easement vacation area. It's depicted in red. And this purple depiction is where the city will reserve additional PUE over the new vacation area in order to maintain and protect our 6-foot perimeter public utility easement. As I mentioned, the property has a single-family future land use designation and a single-family residential zoning designation, as do all surrounding properties. This will enlarge the area by vacating the upland canal right-of-way, and the owner is eligible to file the vacation requests. In reviewing vacation requests, staff examines these based on LDC 3.4.5.b, 1 through 5. The first of those items questions whether the plat, easements, or rights-of-way are required by the city for future transportation, access, water management, or public utility purposes. And staff found that the right-of-way consists of a narrow, unexcavated strip of land, which lies between the southern property line and the canal. The right-of-way is not part of the functioning canal system and does not provide any type of mobility or transportation benefit. The applicant will provide a 6-foot wide perimeter easement around the expanded site. Item 2 questions whether there are any required easements necessary to accommodate the vacation or the right-of-way. Staff found that sufficient easements will be retained by the city for providing a continuous perimeter easement around the expanded site. No additional easements are necessary. Item 3 questions if alternate routes are required or available that do not cause adverse impacts to surrounding areas, and staff found that the canal right-of-way proposed to be vacated is not part of any functioning waterway system. Navigability and visibility will not be affected, and the vacation will not cause any adverse impacts to surrounding properties. Item 4 questions whether the closure of a right-of-way negatively affects areas utilized for vehicles to turn around and exit an area. And staff found that the vacation will not result in the closure of a canal and will therefore have no effect on the movement of boats traveling within the canal. Item 5 questions whether local utility providers have given consent to the vacation of the plat, easements, or rights-of-way, and staff found that the local utility providers may require additional easements, staff found that all 3 utility providers provided letters of no objection regarding the requested vacation. LCEC requires a continuous easement to be provided around the perimeter of the site, and conditions recommended by staff do provide that perimeter easement. With respect to the comprehensive plan, staff found that the proposal is consistent with policy 1.15 that identifies the R1 districts being consistent with the single-family future land use classification, and the request is consistent with policy 1.15A as the site will be developed with a density less than the maximum 4.4 dwelling units allowed in the single-family future land use classification. There was a typo on that second slide, and I apologize. Staff is recommending approval of this with two conditions. The first condition being that the vacation of the 354 square feet of canal right-of-way and underlying easements shall be consistent with that shown in the sketch and accompanying legal description prepared by Harris Jorgensen LLC, labeled Exhibit A. The vacation of the 408 square feet of platted easements shall be consistent with that shown on the sketch and accompanying legal description prepared by Harris Jorgensen LLC, labeled Exhibit B. The city shall retain easements sufficient for maintaining a 6-foot wide perimeter easement around the site as depicted in the accompanying sketch and legal description prepared by Harris Jorgensen, labeled Exhibit C. Condition 4, that the petitioner shall pay to the City of Cape Coral the cost of recording this resolution with the Office of the Lee County Clerk of Court. And Condition 5, that the city shall record this resolution with the Office of the Lee County Clerk of Court following the receipt of the recording fees from the petitioner. Staff apologizes for the typo on that slide too. Your conditions and your staff report and the conditions presented today are accurate, and I thank you for your time.
Thank you. I have no questions. This is a public hearing. Are there members of the public who wish to provide comment or input? It appears the only member of the public present today is the elf on the shelf, and apparently the elf has no comments about any hearing so far. So closing the public comment section of the public hearing, bring it back to the applicant's representative. Sir, would you come up, please, Mr. Egan? Thank you. You've heard the testimony of staff. Do you have any additional testimony?
I do not.
Okay, these are easy questions, I promise. Do you wish to incorporate Mr. White's testimony into yours as well?
Yes, I do.
Okay, thank you very much.
Madam Hearing Examiner.
Thank you. Anything else, Mr. White?
Yes, Madam Hearing Examiner, I received one email inquiry on this case and one telephone call inquiry on this case.
Any opinion?
Just seeking information.
Okay, fine, thank you.
Thank you.
All right. I will recommend that the vacation go forward as requested. I understand, Mr. Egan, that time is money. I get that, and so I will attempt to get the recommendation out today, which will move you on to the next step in the process.
No, thank you very much, Madam Hearing Examiner.
Thank you for coming in. Okay. I'm sorry, Madam Clerk, I was making some notes. Madam Clerk, would you please announce the next case? Thank you.
Case number VAC 23-000013, address 5211 Skylark Court, applicant Eric P. Feichthaler, Esquire. The application is a privately initiated vacation request. The property owner intends to vacate approximately 2,620 square feet of Hammerhead Extension right-of-way row and approximately 892 square feet of platted easements along the Hammerhead Extension for Lot 36, 37, 38, and 39, Block 126, Unit 5, addressed as 5211 and 5215 Skylark Court. The vacation would allow for more buildable lots on the subject properties and not affect all other properties along the Hammerhead Extension. The vacation request would not affect any other platted easements on the subject properties, which would remain in perpetuity. Any persons giving testimony today, if you are able, please stand and raise your right hand. Do you solemnly swear or affirm to tell the whole truth and nothing but the truth?
I do.
Thank you.
Thank you, Madam Clerk. Good morning.
Good morning, Madam Hearing Examiner. For the record, Anthony Santor, Associate Planner for Cape Coral City Planning. The case was noticed. We placed a sign on the properties, subject properties. We also put a advertisement in the local paper of record, and we notified all property owners within 500 feet of the subject vacation area and properties.
Thank you. I will find the proper notice was given. Thank you. May we have the applicant's representative up, please? Good morning, Mr. Feichthaler.
Good morning, Hearing Examiner Dalton. Good to see you. My name is Eric Feichthaler. I'm a partner at the law firm of Brand, Adamski, Feichthaler, and Sanchez here in Cape Coral. I have the pleasure of representing Frederick and Wendy Leek in this matter. Most of what I would say would be repetitive to what the staff report is, and I do thank Mr. Santoro for his professionalism in working through this with us over the past several months. Always a pleasure to work with city staff, and I thank him very much for his time on this. A couple of points that he'll bring up that I want to note now. There was, I believe, one letter of objection received. There was a 500-foot radius for advertising, as you know. Someone across the canal on a different street got that notice and didn't read it to see that it was Skylark. They read it to say it was Stratford, and so they said, please don't eliminate our access to our property. They are not part of this application or having any impact based on this vacation. Therefore, I hope that you will note that this objection is not relevant to this particular matter. I also would point out, unlike a usual vacation where new easements would be given to the city, my client is, and both clients are allowing the city to have an easement over the entire vacated area. I bring this up because CenturyLink did request that, and we had no objection. We are solely having this done to have a better setback for the new house that will be built on the vacant land. So, in the conditions of approval by the city, there are two conditions they note that basically the stormwater inlet shall be removed based on what it says in Exhibit D. Exhibit D is blank because they're not at this moment requiring it to be moved and requesting or requiring the pavement be vacated. So we're requesting that conditions 5 and 6 be eliminated because of the easement that will remain in perpetuity over the entire vacated area. In the alternative, if you do wish to keep numbers 5 and 6 into conditions, we would request that the shall word be changed with may upon city request. The drainage right now is great, the grading is great. It would take a significant amount of effort to potentially move that drainage area along with the required grading of the property. With that said, we do stand by for any questions you may have.
Do you wish to incorporate the staff report into your presentation, but for those two conditions you just
Yes, ma'am, we do.
referenced?
Thank you.
All right, I have no other questions. Thank you. All right, Mr. Santoro?
Good morning again, Madam Hearing Examiner. For the record, Anthony Santor, Associate Planner for Cape Coral City Planning. My credentials are on file with the City Clerk's Office. I'm here today to talk to you about Vacation 2313.
Did you want to be construed as an expert?
Yes, Your Honor, please.
I think you went part of the way and then you got distracted by,
Well, I have not presented a vacation case to you before, so I did want to be presumptive in assuming that it would be prudent at this time to specify that, so.
well, I have reviewed your credentials again, and I think that notwithstanding the fact that you've not presented on vacation issues before, I think your credentials speak for themselves, and also your testimony on other matters which could be construed as relevant to this matter as well. I will find you as an expert. Thank you.
Thank you. So the vacation I'm here to talk to you, it is a privately initiated application. The applicant is the representative for two property owners, Frederick and Wendy Leak and Carlos and Kimberly Vasquez. The property is located at 5211 and 5215 Skylark Court. And what we are specifically here to talk about today is the vacation of the Hammerhead Terminus and a couple of associated platted easements with that. So the size for the Hammerhead Terminus is approximately 2,620 square feet. And for the platted easements, we're looking at 892 feet. And the request is to vacate the terminus of the Hammerhead between these two parcels, allowing the parcels to get a little bit bigger. So as we kind of just covered that the Hammerhead terminus sits between these two parcels, the right-of-way is currently developed with a paved 2-lane local roadway. There is stormwater drainage lines and some utility lines, which we will see in Exhibit D, that do reside within the requested area of vacation. The properties are zoned R1 single-family residential, which is similar to the surrounding area, and the future land use classification for these properties is single-family, which is consistent with the surrounding area, which we will see mapping a little bit later on. And the applicant is requesting the vacation to allow for a more suitable building area and layouts for the properties affected by the vacation. So here in the aerial, we can see the two properties in question, one to the north and one to the south. The Hammerhead Terminus being right in this location here at the extension of Skylark Courts Cul-de-sac and Hammerhead Extension. Excuse me, the time change. So here we can see the future land use classification. Everything in yellow is SF, which is the single family classification. You can see it's consistent, not just on this block, but on the surrounding blocks around the canals and the waterways. The same goes for the zoning. everything in yellow is the R1 single family. It is consistent down the block and along the adjacent blocks as well. So the first thing we have is Exhibit A, and this is the area of the proposed vacation. Here you can see the lots to the north and to the south, and the area asking to be vacated specifically in between them right here. We also have Exhibit B, which is the proposed vacation of the 6-foot public utility drainage easement on the northern property, as well as Exhibit C, which is the vacation of the 6-foot utility and drainage easement on the southern property. We also have Exhibit D, which is the boundary survey, which illustrates the properties to the north, as well as the vacated area, and I can see if I can zoom in. You can see here at the terminus of the Hammerhead the existing right-of-way, as well as the pavement and a few other ancillary items. We also have Exhibit E, which is the utility letters, which we will discuss a little bit further on, so I won't go through them. The big thing to note, however, is from CenturyLink, who is requesting that a blanket easement be granted or be retained by the city throughout the entire of the vacated area for utility services. And they provided an exhibit sketch on what they would like to see retained, and that will be brought up a little bit later when we get to the conditions of approval. And then there were two other exhibits, F and G, which just, again, highlight the individual portions of the vacated area returning to the properties to the north, and then Exhibit G, which is the property to the south. So as part of the requirements for vacations, we examined the Land Development Code, specifically LDC Section 3.4.5B.1, whether the plat easements or rights-of-way are required by the city or any future transportation, access, water management, or public utility purposes. The area does sit at the terminus of the Hammerhead, as we have seen. The vacation of the extension does not inhibit access to or from the sites. It also does not inhibit any access from the adjacent areas or the properties that exist and will be maintained with their access next to these sites along the west of the properties. So therefore, staff has determined that the vacated area is not required for the city purposes. We also examined LDC Section 3.4.5.B.2, whether any required easements are necessary to accommodate the vacation of any plat easements or right-of-way. So typically, the city would request that the public utility drainage easement of 6 feet be maintained along every property. And that is for utility access, drainage uses for each property. However, the applicant has agreed to an easement over the entirety of the vacated right-of-way, which could serve the purposes of maintaining the perimeter easements for drainage and utility. So given that, an easement is required and will be provided for within the vacation. We also examined LDC Section 3.4.5.B.3 if alternate routes are required or available that do not cause adverse impacts to surrounding areas. So the vacation, as stated before, is at the terminus of the Hammerhead extension. It does not affect any of the adjacent properties, and therefore there are no alternate routes that are necessary with the proposed vacation. We also examined criteria number 4, which is LDC Section 3.4.5.B.4. If the closure of right-of-way will negatively affect area utilized for vehicles to turn around and exit an area. The vacation is at the end of the Hammerhead again. The proposed vacation will not affect access to or from other properties. It will not affect access to or from the subject properties, and the cul-de-sac will be maintained in its existing level along with the remainder of the existing Hammerhead extension, and therefore will have no impact on the existing level of service for turnaround of any of the properties. So therefore, the proposed vacation does not negatively affect vehicular access or turnaround. We also examined LDC Section 3.4.5.B.5, whether local utility providers have given consent to the vacation of plat, easements, or right-of-way. The local utility providers may require additional easements or relocation of existing utility facilities to complete the vacation. So out of the 3 utility companies, all 3 gave letters of no objection. LCEC did specify that they would like the 6-foot public utility drainage easement maintained around the property. And then CenturyLink, as we talked about a little bit earlier, did specify that they would like a easement to be established over the entirety of the vacated right-of-way. Within their LOI and with testimony today, the applicant has agreed to that. We also analyzed the comprehensive plan in relation to this request and found that the request and the properties are consistent with Chapter 4, Policy 1.15, specifically that the existing zoning district R1 is consistent with the future land use classification of the properties of single family, and that the existing properties are built, or when they are built, if they are redeveloped, will be built to the allowable 4.4 units per acre given their size. So therefore, we found that the request was consistent with this goal in the comprehensive plan. So therefore, given the analysis that was conducted regarding this request, city staff recommends approval with specific conditions. And those conditions are as follows. One, the vacation of the 2,620.35 square feet of right-of-way shall be consistent with the sketch and accompanying legal description prepared by Harris Jorgensen LLC dated 5/11/2023, entitled Exhibit A. Number two, that the vacation of 892.54 square feet of platted easement in lots 36, 37, 38, and 39 in Block 126 shall be consistent with the accompanying legal descriptions prepared by Harris Jorgensen LLC dated 5/11/2023 on both and entitled Exhibits B and C. And that three, the city shall retain an easement over the entire area of the vacated right-of-way, that is the 2,620.35 square feet, as identified in the letter from Lumen, which was identified as CenturyLink in Exhibits to the applicants that were dated 7/4/2023, which is entitled Exhibit A, which resides within Exhibit E. All other existing easements, including the existing perimeter drainage and utility easements throughout the properties identified as 5211 and 5215 Skylark Court, shall be maintained in perpetuity and are not part of this vacation. Number four, in the event utilities are found within the vacated area, the owner shall be responsible for bearing the cost of relocating the facilities to a new easement. In the event utilities are damaged during construction activities, the owner shall bear the cost of relocating the utilities to a new easement and repairing said utilities. Number five, within 180 days, the owner of the site shall remove the existing stormwater inlet located within the vacation area and relocate the inlet to existing city right-of-way and pipe to and from the new inlet, generally as depicted in Exhibit D. That's where we see the stormwater is illustrated in Exhibit D, so relocating that out of the easement area. At the sole discretion of the city, the owner shall grant all necessary easements from any new or modified stormwater system if required. All improvements shall be inspected by the city. The cost of all improvements identified in this condition shall be borne by the owners. Number six, within 180 days of approval of this vacation request, the owner shall remove the pavement associated with the vacated street that occupies each site. Each area shall be sodded following the removal of this pavement or may be improved as permitted by the Land Development Code. Number seven, that the owner shall pay to the city of Cape Coral the cost of recording this resolution with the Office of Lee County Clerk of Courts. And finally, number eight, that the city shall record this resolution with the Office of the Lee County Clerk of Courts following the receipt of the recording fees of the owner. I do want to note that prior to distribution of materials to the hearing examiner, staff had not received any correspondence. However, after the deadline had passed, staff did receive an email notice of objection from residents a block to the northeast, that did reside on Stratford Court. They, as the applicant had alluded to, when they had received the public notice, they had misconstrued Skylark with Stratford and thought that their property was the subject property in question and wanted to object to the vacation, which they had no knowledge of. Staff did reach out to them and was able to talk with them and talk through that this was not affecting their property, that they were a block, and that we were notifying them because they were within that 500-foot boundary. And they thanked staff and then wished to remove their objection. And so therefore it was not transmitted to the hearing examiner as they had removed their objection following its submission. But I did want to make you aware of it. Other than that, staff has received no calls either for or against or any inquiries into this project.
Do you have any response to the applicant's representative's testimony regarding conditions 5 and 6?
So this was brought up to staff recently, I believe it was a couple of days ago, when the applicant had requested that the condition, we look at the removing specific conditions. Staff does not have any objection so long as the city retained the option of requiring that those be relocated at the city's behest. So as long as the city can specify that those items may need to be moved in the future and that the applicant is bearing the cost of those, staff does not necessarily have specific objections.
Does our Assistant City Attorney have a comment?
John Niclerni, City Attorney's Office. If staff is not objecting and is agreeable to modifying conditions 5 and 6, but keeping it, if required, by the city, we would request that it not read exactly the way the applicant suggested and change shall to may. I think it would be more appropriate to read something to the effect of with the 180, both 5 and 6, if agreeable to staff, with the 180 days of approval of this vacation request, the owner shall, and if required by the city, the owner shall remove, not change it to may. If required by the city, it shall be required.
You want to keep the 180-day restriction?
Yes.
Yeah, and I would recommend that we add it within 100 of approval of this vacation request to number 5, which was inadvertently left out. It just says within 180 days. But yes, staff would like to keep the 180 days from approval of the vacation request, and if required by the city, then the applicant shall act in both cases.
All right, all right. Are you okay with that, Mr. Santoro?
I am acceptable to that.
Okay, fine.
yeah, sure.
Wait, not your
Why you
turn.
said me.
Not your turn, it's okay. Anything else, sir?
I would like to incorporate my staff report into the presentation, as well as exhibits A through G.
Okay, thank you very much. I have no other questions. This is a public hearing. Are there members of the public who wish to provide testimony or input? Seeing none, bring it back to the applicant's representative. I'm sorry, I didn't mean to interrupt you, but
No, I didn't mean to interrupt you, ma'am. I thought you said my name. I don't know how I could misinterpret something else with my name, but
I congratulate myself that I finally pronounced it correct.
everyone did today. You got A+, everybody. Thank you.
You had some comments, sir.
Oh, I just wanted to agree with the city attorney's comments, and basically, if within those 180 days, if it was requested, then we will comply with that, and if not, then that would be great. I think when they look at the site, the city will agree that probably everything should remain as is with regard to drainage and the road itself.
All right, so you're okay with the language as recited and modified today?
Yes, Your Honor, we are.
Okay, thank you very much. Anything else, sir?
No.
Okay, thank you. Mr. Santoro, anything else?
Nothing further at this time.
Okay, fine. Thank you very much. I will recommend that the vacation request go forward with the condition as modified as proposed by the Assistant City Attorney, as agreed to by staff, and as accepted by the applicant's representative. As you've heard me say numerous times, because you've been sitting here all morning, sir, time is money. I will attempt to get it out as quickly as possible. So thank you very much. I will recommend the approval. At this time, I will close this hearing. Thank you. All right, Madam Clerk, can we proceed to case listed under number E? Thank you.
Case number RZN 23-000008, address 2304 Southwest 8th Place. Applicant, Hungry Catfish Farms LLC. The applicant is requesting a rezone from professional office P1 to single-family residential R1 for 12 properties totaling 3.06 acres. The parcels were placed in the single-family residential SF future land use classification in 2022. The rezone will allow for construction of single-family homes. The parcels have frontage on Southwest 8th Place and Southwest 24th Street. Any persons giving testimony today, if you are able, please stand and raise your right hand. Do you solemnly swear or affirm to tell the whole truth and nothing but the truth?
I do.
Okay, thank you, Madam Clerk. Good morning, Mr. Boyko.
Good morning, Madam Hearing Examiner. For the record, Chad Boyko, Principal Planner with the City's Planning Division. Before the applicant gives their presentation, I am just here to state that this case was properly advertised with an advertisement in the local newspaper of circulation. There was a sign placed on the property, and there's also mailings that were mailed out to residents within 500 feet of this property. And all of this was done 10 days prior to this case being heard.
Thank you. I will find the proper notice was given. Okay, thank you. Ms. Miller, good morning.
Good morning, Linda Miller, Vice President of Avalon Engineering, representing Dean and Michelle Pulley, who own Hungry Catfish Farms LLC on the rezoning case 23-8.
I think they get an award for the most interesting
I know, I
named
like their
LLC.
name.
I assume they're fishermen. Thank you.
I'm requesting to be recognized as an expert witness for this case due to my credentials that are on file and also my experience with similar zoning cases.
I will find you as an expert regarding issues that are addressed in this matter today, based upon your CV, which has been previously reviewed by me, and also based upon your prior testimony regarding matters that are similar to those today being considered. Thank you.
Thank you. This case is requested a zoning map amendment for 3.06 acres from the city's professional zoning category to R1 residential single-family zoning district. The subject parcels have a single-family future land use, which was amended in 2002. The current professional zoning is not consistent with the single-family land use category. The subject parcels are located at the corner of Southwest 24th Street and on the west side of Southwest 8th Place. The subject parcels consist of 12 properties totaling 3.06 acres in Block 4380, Lot 49, Block 4381, Lots 1 through 18, and Block 4382, Lots 25 through 29, in Section 27, Township 44 South and Range 23 East. The future land use designation of the subject parcels is single-family residential. Parcels to the north, west, and south of the site have the same single-family future land use category destination. Parcels to the east along Skyline Boulevard have commercial professional future land use. The zoning for this particular parcel is currently professional, with the parcels to the north and west zoned R1, which is residential single-family. The single-family land use and the professional zoning on the subject parcels are not consistent. This zoning amendment is being requested to bring the zoning of the parcels into consistency in order to develop single-family homes within the city's residential single-family zoning. There's a couple of criteria that's required for zoning cases. Per Article 3, Section 3.4.6.a, applicants for a change in zoning may be initiated in the following manner. And our selection here is the property owner with at least 51% of the land in the proposed zoning area. The Pulleys own 9 of the 12 lots, parcels, and which totals 2.13 acres or 70.5% of the land area proposed in this zoning amendment. Per Article 3, Section 3.4.6.b, an applicant for a rezone shall be reviewed in accordance with 6 criteria. The first one is whether the proposed zoning district is consistent with the city's comprehensive plan. Policy 1.15 establishes the comparable zoning district for each future land use category, and that's provided in Table 1. As you can see, single-family land use is consistent with the R1 zoning or RE, which is residential estates. Number 2, whether the full range of uses allowed for the proposed zoning district will be compatible with the existing uses in the area under consideration. The parcels adjacent to the subject parcels to the north, west, and south have a single-family land use and zoning. Several of the adjacent lots have been developed with single-family residential homes. The R1 district will be compatible with the existing residential uses in this area. The city's single-family zoning district permits a limited amount of uses, with single-family homes being the only residential use. Commercial uses within this district consist of a family daycare home, community residential home with up to 6 residents, home-based businesses, primary and secondary educational facilities, and religious facilities. The property owners are intending to develop a single-family home upon approval of this zoning amendment. Number 3, whether the full range of uses allowed in the proposed zoning district will be compatible with the existing and the potential uses in the area under consideration. The character of the neighborhood is mainly single-family residential. The proposed R1 zoning district would permit single-family residential homes, which is compatible with both the potential and the existing uses. Number 4, whether the proposed zoning district will serve a community need or a broader public purpose. Currently, the lots are not buildable. There's not consistent land use and zoning on the lots. The future land use of the lot is single-family, which is not consistent with the current zoning of professional. A zoning map amendment is required to bring the lots into consistency and permit the development of these lots with a single-family residential. Number 5, the characteristics of the proposed rezoning area are suitable for the uses permitted for the proposed zoning district. The subject parcel is a combination of 24 lots, 12 building sites containing a total of 3 acres. The depth of the lots is 125 feet. Most of the lots are located along canal front. Because of the characteristics of this neighborhood in this area, the proposed R1 zoning district, which is consistent with the future land use, would permit a single-family home which is suitable for this area. Number 6, whether a zoning district other than the district requested would create fewer potential adverse impacts to the existing uses in the surrounding area. The single-family future land use category is only consistent with the city's R1 residential single-family or R3 residential estates as traditional zoning districts. Of course, you could use the PUD too process. The R3 residential estates zoning district requires a minimum lot area of 40,000 square feet, which is not consistent with the size of the subject parcels, as most of the lots contained within this request are only 10,000 square feet. In reviewing the criteria and this presentation, I suggest that this proposed zoning is consistent with the city's comprehensive plan as provided in the city's staff report and provided in my application letter of intent and presented today in this presentation. We accept the Planning Division staff report and the staff's recommendation of approval with no conditions. Please accept this presentation, the application documents, the Planning Division staff report, and all the supporting documents submitted for this case into evidence. And I stand by to answer any questions you may have.
At first blush, it looks like this is spot zoning, but it's really not because the entire future land use has been modified. So I just wanted your opinion about that.
So I can't remember the date. I think in 2009, the city changed the land use on the property and the zoning on the property to be commercial, hoping that the commercial development that was on Skyline would extend back into this corner, and that just didn't happen. So we did bring a case in front of City Council to change the land use. It was commercial professional, not really difficult to build a commercial development back behind a storage facility in that area, and really not as compatible as, you know, a residential development next to the neighbors. So we brought that case forward. So this is the last step to get them to be able to build homes.
So in your opinion, this is not spot zoning, correct?
No, not spot zoning.
Yeah, I didn't think so either, but I wanted your opinion. Thank you very much.
Thank you.
All right, Mr. Boyko, thank you.
Thank you, Madam Hearing Examiner. Before I begin, I would like to be recognized as an expert witness based upon previous testimony and my credentials that are obtainable with the City Clerk's office.
I will find you as an expert based upon your testimony in other cases that are similar to the issues before us today, and also based upon your CV, which is a record with the City Clerk's office.
All right, thank you very much. So you heard this is RZN 23-8. This is privately initiated. The applicant for this is the Hungry Catfish Farms, LLC. They are the applicant, however, they're not the sole owner, however, they do own more than 51% of the properties in this, so they are allowed to come forward with this rezone, including some extra properties that they do not hold title to. It's located a little bit north of Veterans Parkway and west of Skyline Boulevard. It's a little over 3 acres in size. There are city utilities that are available to the site with water, sewer, and irrigation. And then the applicant's request is a rezone from professional office, or P1, to the single-family residential R1 district. We have an aerial map that's in front of you. You can kind of get a layout of the land. To the north, to the west, to the east, you have primarily residential uses with a couple of scattered undeveloped parcels. To the east, you have a storage facility that has been built on that property that has frontage on Skyline Boulevard, and that was part of the impetus probably behind the applicant's request in 2022 to amend these properties to a residential classification, as the storage facilities development sort of eliminated any sort of assemblage and development out to the canal portion of this property, limited the frontage, the access, and things that are generally sort of favorable to commercial development. To the south, you have Veterans Memorial Parkway, and then across that to the south, you do have a commercial development. However, there's quite some distance between these properties and that property that is to the south. So the existing zoning and the proposed zoning maps are here before you. The map on the left indicates the existing zoning. It shows the 12 properties in question as zoned as P1. Surrounding zoning to the north, to the west, and to the east is single-family residential. And then, I'm sorry, the north-south, or you have north, west, you have single-family residential. To the south and to the east, you have commercial zoning, including that storage facility that we indicated. And then on the map on your right, you show the proposed zoning would have this into the R1 district, and it would link up with properties that are sort of to the north and to the west that also have that same zoning that are abutting a couple of the properties in question. So we mentioned these are 12 undeveloped parcels, totaling just a little over 3 acres in size. It was changed to the single-family residential future land use in 2022. It only has access from local streets. It does not have any arterial or collector roadway access, which is usually something that commercial development is looking for. Hungry Catfish Farms owns 75% of the lots in question, and the rezone would allow for single-family homes to be built on these 12 properties in the future. So we looked at this firstly for our land development code with the 6 standards within that asks us to analyze rezone cases. The first standard is whether the proposed district is consistent with the city's comprehensive plan. Staff finds that the proposed R1 district is compatible with the single-family future land use designation. There is one other land use that is compatible with this. However, that does have some lot size requirements that would not apply to these properties in question. That's the residential estate district. The second standard is whether the full range of uses allowed in the proposed zoning district will be compatible with the existing uses in the area under consideration. Staff notes that the R1 district allows single-family homes as the only residences that are allowed within that zoning district, other than the storage facility that is to the east, and then you have those commercial uses we talked about that are located to the south. You have residential homes that are located to the north and to the west. They're single-family homes, so therefore the proposed zoning of R1 would naturally be compatible with those existing homes that are in that area. The commercial uses to the south of Veterans Parkway are some distances away, so there really isn't any sort of compatibility issues that you have with those in the future. And staff notes that the homes would be compatible with the already existing single-family homes. So the third standard is whether the range of uses allowed in the proposed district will be compatible with the existing and potential uses in the area under consideration. The majority of the properties that are nearby to this site are currently developed either with the single-family homes or with that storage facility that is located to the east. The few remaining undeveloped lots for the potential uses are zoned single-family as well, so this zoning would be compatible with those potential uses that could be developed in the future for those undeveloped pieces of property. The fourth standard is whether the proposed district will serve a community need or a broader public purpose. The rezone would remove a small portion of commercial land. However, staff notes that it has already been changed from a CP land use to single-family land use. The comp plan and LDC have standards for encouraging appropriate commercial development with quality access, frontage, and depth. The site did not exhibit any of those standards with the depth, the frontage, or the access. So therefore, by making the site, zoning the site into something compatible, with how the lots are laid out, its access and location, staff does find that it meets that broader public purpose of not putting in incompatible uses in an area where they wouldn't work. The lots don't have any of those commercial characteristics, so therefore it is reasonable to place them with a zoning district that is compatible for what they have on that with their characteristics. The fifth standard is the characteristics of the proposed rezone area are suitable for the uses permitted in the proposed district. The site's 12 undeveloped parcels, we mentioned previously that it lacks the commercial, ideal commercial qualities that you're looking for in order to have non-residential development. The surrounding area is mostly residential, so therefore you would have presumably 12 homes that would sort of fit seamlessly into this area as it is. And then the last standard is whether a zoning district other than the district requested would create fewer potential adverse impacts to the existing uses in the surrounding area. The only other district allowed in the single-family land use, other than the RE, which we mentioned would not work for this because of the lot size requirements, is the PUD district. So therefore, staff finds that the R1 there really isn't anything else that would create less impacts than what is currently proposed. We also looked at this per the comprehensive plan, which is Chapter 4, Future Land Use Element, our Table 115, which lists out the compatible land use categories and zoning districts, and staff finds that the R1 district is compatible with a single-family future land use designation. Our recommendation, based upon analysis of the comprehensive plan and the land development code, is that the proposed rezone to the R1 district is consistent with both of those documents that we utilize in terms of analysis, and staff recommends approval of the proposed rezone request. We did receive one phone call of general inquiry. They weren't quite, they thought that the properties were already residential based upon the previous future land use amendment. However, I had to explain to the caller that there is a two-step process to make properties consistent with both the land use and the zoning, and it was basically just a phone call of inquiry at that point. So I'm here for any further questions.
I have no questions, thank you. This is a public hearing. Are there members of the public who wish to provide input or testimony? Seeing it none, I will close the public comment section of the public hearing, bring it back to the applicant's representative. Ms. Miller, anything further?
No, I just would like to thank Chad for his presentation today. He actually reviewed the case more as why it's not suitable for commercial, so I appreciate that. And I would like to incorporate his presentation and his staff report in the evidence.
Okay, fine, thank you very much. All right, nothing else, Mr. Boyko? Okay, thank you very much. I will recommend that the rezoning goes forward as requested. I will attempt to get my recommendation out as quickly as possible. As we know, time is money, and everyone needs to have their situations move forward as quickly as possible. So with those comments, was there something else?
Nope, thank you. I just wanted to say happy Thanksgiving.
Oh.
Have a great holiday.
Thank you. You as well. Thank you very much. And with those comments, I will close this hearing and move on to our next item, which is a recitation of the dates and times of the next hearings for 2024. Madam Clerk, do you wish me to enunciate each one of them, or would you rather have the our very competent city clerk, may I say, just post them? What's your preference?
Either way, or you can just announce that they'll be posted on the city website.
All right. So I will announce that our first hearing in 2024 will be Tuesday, January 16th, 2024, commencing at 9 o'clock here in Council Chambers in Cape Coral. Other than that, I will take the clerk's advice and request our highly competent city clerk to post them on the city website. Our next hearing date, however, in 2023 will be, and I've lost that piece of paper, I believe it's December 5th?
December 5th.
December 5th, 2023, commencing at 9 o'clock here in Council Chambers. With those comments, we stand adjourned at 10:17. Happy Thanksgiving, or however you choose to celebrate the upcoming couple of days off. I wish everyone in the city of Cape Coral and elsewhere a happy holiday. Thank you.